everyone, this is the first in a new series of short videos that I've put together on topical issues in planning law, environmental law, and there'll be some compulsory purchase content in due course as well. I'm working from home during the lockdown, so I thought that I'd take the opportunity to put out the material that I'd usually be presenting in seminars in a more informal way. I've called it Planning Law Tea Break. Planning law because planning, environmental and compulsory purchase law would have been more accurate but was too long, and tea break because tea breaks have taken on a much more central role in my working day at the moment whilst I'm not leaving the flat very often. So I thought that I'd keep the videos to the right length to accompany a cup of tea or a cup of coffee, and they'll all be between 5 and 10 minutes long. I am though already regretting not having called it the Planning Law G and Tea Break because, full confession, the bottles that you can see over my shoulder are my gin collection. Maybe I should do a special episode on a Friday evening with a glass in hand. Anyway, the first case that I want to discuss is the recent High Court decision in Gladman and Secretary of State for Housing, Communities and Local Government that was handed down last month. I'm not sure continuity is going to be a strong point of these videos. Anyway, the Gladman judgment was handed down by Mr Justice Holgate on the 6th of March, and the context for the decision is section 38(6) of the Planning and Compulsory Purchase Act 2004, which requires planning applications to be determined in accordance with the development plan unless material considerations indicate otherwise. The NPPF obviously is a material consideration, and the tilted balance, which is a subject of discussion in Gladman, is now found in paragraph 11d2. The question in Gladman was whether the tilted balance should be struck without taking into account development plan policies, so leaving development plan policies to be weighed separately under section 38(6). That was the claimant's argument. The Secretary of State contended against that and argued that relevant development plan policies may be taken into account in applying the tilted balance. Mr Justice Holgate held that development plan policies were not excluded from consideration in applying the tilted balance. The claimant pointed out that the tilted balance requires the proposed development to be assessed against the policies in the NPPF taken as a whole, so it doesn't say that there should be assessment against development plan policies. You might remember that in Hopkins Homes, the Supreme Court held in relation to the 2012 NPPF that the reference there to specific policies in this framework, so those policies restricting development, should be read actually as including related development plan policies. So the claimant in Gladman argued that the position had been reversed in the 2019 NPPF because footnote 6 now expressly states that the policies in question are NPPF policies rather than development plan policies. But in Gladman, Mr Justice Holgate notes that footnote 6 applies only to paragraphs 11b1 and 11d1 and not to the tilted balance in paragraph 11d2, so the alteration does not apply to the tilted balance. The claimant contended for a two-stage approach, so first you undertake a separate assessment of the proposed development against NPPF policies, disregarding development plan policies for that first stage, and then you apply section 38(6), so you assess the proposed development against the development plan policies, and you factor in your assessment of the proposed development against the NPPF policies as a material consideration. The claimant said that if a development plan policy is required by the NPPF to be treated as out of date, for example because there's no 5-year housing land supply, then it's improper to take it into account in the tilted balance assessment because that would involve an element of double counting or circularity. Mr Justice Holgate observed that where development plan policies are out of date, the decision maker still has to consider the weight to be given to them, and he noted that in Hopkins Homes, Lord Carnworth had explained that the weight to be given to development plan policies in the tilted balance was a matter of judgment for the decision maker. That, of course, was under the 2012 NPPF, but Mr Justice Holgate confirms in Gladman that the position remains the same under the 2019 NPPF. Mr Justice Holgate observes in particular that development plan policies might be out of date because the decision maker has assessed them to be out of date, but equally development plan policies can of course be out of date because they're deemed to be out of date because there's no 5-year housing land supply. In the latter situation, the development plan might be recently adopted and up to date in all material respects. So bearing that in mind, It's clearly right, in my view, that the decision maker remains able to assess the weight to be given to development plan policies in the tilted balance. The Supreme Court in Hopkins Holmes did emphasise that a conclusion that a policy was out of date did not dictate the weight that was to be accorded to it. There are two practical points in particular that I think can be taken from the judgment. The first is that Mr Justice Holgate held that it is permissible for the decision maker to assemble all the relevant material and to apply the two balances, as he referred to them, so the tilted balance and the section 38(6) presumption, either together or separately. So you can have one overall assessment, or you can have a two-stage assessment. The second practical point, I think, is really one for the lawyers. The claimant sought to rely on a witness statement that sought to analyse a substantial number of decision letters. Mr Justice Holgate concluded that the witness statement was essentially irrelevant because the decision letters under challenge either did or they did not contain a misinterpretation of national policy. And there's a clear statement in the judgment that parties should not seek to file evidence of this kind in future challenges, and that generally the evidence in a legal challenge must be confined to the material that was before the decision maker when making the decision. Mr Justice Holgate also observed that it's not the function of a witness statement to provide a commentary on the documents in the trial bundle or to make points that are essentially matters for legal submission. So that's everything on Gladman. I hope it's useful, and take care.